Yeah. Good, man. Have a seat, brother.
Yeah, turn around.
Better?
Yeah, this looks good. Turn around. You're on, and then we'll pop. Pop.
Oh.
Sweet. Nicholas Silvas, thanks for coming out to the Founders Lounge.
Happy to be here, guys.
Yeah.
Yeah, so I actually know your mom, and it's always good to be able to have a family business and be able to continue on the legacy. And you guys aren't in an easy business. Estate planning, families, that type of stuff. So we're going to get into it heavy. Laws, sometimes some of these subjects can be kind of heavy, but we're going to have some fun with it and just have a little tequila and enjoy yourselves,
Absolutely, yeah.
Yeah, you're looking sharp today, man. I love the stash.
Thank you. I just started growing it out and curling it in the last 6 months or so.
So what's a good tip for some stash connoisseurs out there? Is it like a wax, or how do you train it? How do you?
A good solid wax. You got to get the.
It's got to be a real stiff hold.
Got to be like the extra strong hold in order to make it last throughout the day. I tried the medium.
It just didn't.
It doesn't hold it. It doesn't hold it for more than like 30
It
minutes.
starts to become like the guy. What's the guy on Sonic the Hedgehog? The Dr.
Eggman.
Eggman. He gets like.
Yeah. Well, it starts drooping, and you just look so sad. It's not good.
Yeah.
It's not good.
Well, it's later in the afternoon, and it's got a good rise to it. There.
Yeah, well, thank you.
Yeah, cool.
So, Silvas Law, Nicholas in the house. Let's jump into it, brother. Does your law firm only primarily focus on wills and trusts? Is that your bread and butter?
Yeah, so we are a comprehensive estate and business planning law firm. So you see a lot of law firms that are just estate planning, so they just do wills and trusts and powers of attorney, that kind of thing. And then you see the business planning law firms, which just do business formations, mergers and acquisitions, that kind of thing. And there's very little overlap between them. For the most part, our firm is a comprehensive estate and business planning law firm. So we marry both of them together because we saw this unmet need with our business owner clients who've been to estate planners in the past, and they just aren't familiar with dealing with business entities and how they all operate. And then, of course, you have the business attorney side who aren't familiar with trusts and wills and planning for business owners, estate planning for business owners. And so we saw that unmet need, and so we just kind of married the two together. And it's, I think, worked out great. It's a great product and service for our clients.
One big powerhouse, one-stop shop.
That's freaking awesome.
That's the idea, yeah.
I know some of this can't be legal advice, but say I missed the boat, didn't get a prenup, deep in the marriage, a few kids in, and it's hard to bring up with your wife, like, hey, let's get a like a finance,
let's get a post-nup.
Let's get a post-nup. Is there ways to possibly, for someone that want to set up a meeting with you guys, to kind of set up a trust to sort of structure things in a way that where I could put up my kids' names or things like that? Or
Yeah. So we have clients come in all the time, and we'll do post-nups, not just because they're getting ready to divorce their spouse, but for a bunch of other reasons like estate tax issues, creditor issues, and so those are all reasons you might want to do that. And if the concern is I have my stuff from a previous relationship or prior from the marriage, whatever it is, we can use a trust to kind of orchestrate how you want those assets to be distributed, protect them, all that kind of stuff through revocable trust specifically. Irrevocable trust as well, but primarily the vehicle we like to use is revocable trust for most people, most business owners.
I didn't even know you can do that. Hey, we missed the prenup, and then you could do the post.
Oh, there's
I didn't know that.
There's multiple layers to it all.
Yeah, there's a lot of tools. That we can use.
I mean, when you get into asset protection and things like that too, this isn't just about being able to handle your affairs once you're done, or if you're going to transition. Like you guys are handling things from a personal level, but also for business. So if you're looking to maybe sell your business, that'd be a good time to come in and say, hey, look, we need to really make sure we got everything structured properly. So, because a lot of times small business owners, maybe you have an S corp or LLC with your accountant, but you're not like heavily. It's not like you have a huge.
Yeah.
I mean, you may be doing $20 million a year, but you don't have a massive company with a board.
Yeah, exactly.
Big, you know what I mean? You're kind of doing it, but you're not really.
With employees, of course. But I mean, the greatest time to come in, when you're getting ready to sell and do your planning is years before you're getting ready to do a sell. I know this broker for business sales, and she always tells me that you need to come talk to an attorney or me years before, at least 2 to 3 years before, optimally, so we can structure your business properly. Because unfortunately, a lot of small business owners are running their business, at the speed of business, right?
Yeah.
They're not properly documenting everything they do. Sometimes their bookkeeping is sloppy. They don't have a great accountant or bookkeeper and all this stuff. And so things just get kind of messed up. The
Yeah.
paperwork's not all there. And so making sure that's all planned out before you sign the sales contract is incredibly important to make that process go smoothly, and also make sure you get top dollar for your business.
Got it. And so let's dumbify it. So do people
Simplify it.
yeah, dumbify it? Do I really need a will, or is it just a better option?
So it depends. When I meet with clients, what I look at are what are your goals, and then what assets do you have. So I look at where you're at now, what assets do you have, where do you want to be, right? And so once I have that conversation with them, then I can say, based on your goals, what you want, the assets you have, this tool, whether it's a will or a revocable trust, will work best for you. And of course, when I'm looking at the assets, there are some big red flags that would make me recommend one or the other. Primarily business interests, my small business owners, right? If you own a business, I'm going to almost always recommend a trust, unless you say, I don't care about probate. My kids can be stuck in probate. I don't care.
Yeah.
When some people do say that, they do say
Good
that.
luck and have fun with that.
What actually happens if someone dies without a will?
And then you're stuck in that.
You're
probate
stuck in.
process.
You're basically in. What do the Catholics call that when you're in the middle between everything?
Purgatory.
Purgatory. You're basically in legal purgatory.
Well, let's dumbify it for the audience. What does that mean? So what does probate means?
Yeah. So probate is kind of a catch-all term that is basically estate administration. What does that mean? Everyone has an estate. An estate is just the assets you own, the things you own when you pass away. That's what an estate is. And so when you pass away, your assets there's something has to be done with them. They have to go somewhere. And that is done through the probate process. Now, if you don't have a will, in any case, whether you have a will or you don't, you are going to court. You're going to a probate court, and the court is going to oversee the administration of your estate to a greater or lesser degree. But if you don't have a will, that process is a lot more expensive and takes much longer. It can be years. It can be years.
Really?
Yeah,
it can be extended years. years.
I had a probate finalized beginning of this year that lasted for over 2 years.
Wow.
It can be a long time before these things close, depending on your complexity, if you had a will or not, or the fighting amongst heirs and beneficiaries and that kind of thing.
Yeah, and when you become to like entrepreneurs, they could have multiple properties, multiple businesses, partnerships.
Oh yeah.
And it's not all connected through always, and it can get pretty complicated.
It can get very messy. Yes, especially when you have I see this all the time with my business owner clients. They have a business partner. They're working for years together, and then one of them passes away. Well, what happens to his, say, 50% share in the business? Well, that's probably going to go to his wife or to his kids. And the surviving business owner, he might not want to be in business with the wife or the kids, right? He was doing business with the business partner. And that can create a big headache, right? Because now you're making decisions with these other people you haven't worked with before. And then, they want to do things, you want to do other things, and can cause a big headache, especially again in that court process.
And this is happening quite a bit.
out.
Like you're seeing this quite a bit happening.
Oh yeah,
It happens all the time.
Really? Okay.
And so that's why I always try and encourage my business owners to come in and plan well in advance of, your potential demise, because once you pass away, you lose all control. You can't do anything anymore. You have no say. It's the state, and then of course the people who are left to clean up your mess.
Oh my gosh. So, can a trust really help a family avoid probate, and how does that work?
Yes, it can. So, as I said earlier, right, there's you have wills, and then if you don't have a will, either way you're going through probate, right? A will is a piece of paper with ink on it until it is approved by a judge going through that probate process. A trust, on the other hand, a revocable trust specifically, also known as a probate avoidance trust, completely avoids the probate process. And I always tell clients to kind of imagine a trust like a little red wagon, like a child's wagon. that they drag around with the handle and they have all their little toys in it. A trust operates essentially the same way. You put your assets, your toys into the wagon, and you hold the handle. While you're alive, you can control what goes in, what goes out, spend your money, move your things just like you normally do. However, when you pass away, the trust agreement, the rule book, so to speak, says what happens, who takes that handle, where those toys go, without ever stopping at the probate court. And so you're avoiding, that whole expensive, prolonged court process. Everything remains private because, of course, court is all public record. So you're keeping your assets and your family details all private. So that's a big selling point. And it's just, that is how really a trust works in I guess, layman's terms. But the big hiccup with trusts is that you have to get your toys into that wagon.
You got to make sure it's documented properly.
Correct.
You're not crossing over into personal thing. You have to keep it in its own.
Yeah, because
it's got to be its own little thing.
Exactly. Yeah. If your toys are, again, going back to that wagon analogy, all over the floor, right, still in your personal name, that wagon's not controlling them. And and I see this all the time from clients. They come bring me a trust that they had done 20 years ago, have me review it, and I go, yeah, it looks good. What's in it? And they and then they'll say, oh, everything's in my personal name, and I just got to tell them it's not going to do you any good.
That's not what that was made for.
No, it's not. So we have that conversation. I give them really that same spiel, and then we just work on moving their assets from their personal name into that wagon, into their trust, so that it can do what it's designed to do.
Wow. At what age should someone start estate planning?
When they're born.
When they're born.
Fresh out of the womb.
Financial planning for sure. Yeah, but let's see. The moment in Texas, again, Texas, you're an adult when you turn 18. When you turn 18, your parents no longer have the ability to make medical decisions for you or financial decisions for you. And so as soon as you turn 18, you need to do at least some rudimentary estate planning, whether that's just getting a medical power of attorney so that someone can make medical decisions for you if you're in a car accident or you're in the hospital, something like that. And a financial power of attorney so someone can, access your bank account, your car title if it needs to be sold because you're in that wreck, whatever it is, right? Again, when you're 18 years old, you need to do your own estate planning to a greater or lesser extent, depending on your assets, of course.
Wow. Is estate planning only for wealthy people, or should everyone just have a plan?
Everyone needs an estate plan. As I said, like you're 18, you need something. As long as you own any assets, really. Also, as long as you have an estate, everyone has an estate. Remember, your estate is just the things you own, right? And so, as long as you have anything, you need to do something. And that can be as easy as, simple beneficiary designations, again, depending on your goals and what situation you're in, right? You can just, beneficiary designations and a simple will and you're good. Or it can be something, super complex that we spend hours and hours working on together. But everyone needs something regardless of how many assets you have, how old you are, and once you turn 18, because that's all it is. You have an estate, something, you have assets. If something happens to you, those need to be handled in some way. They need to go somewhere.
Wow. So I had an opportunity to meet Nick at an event. He had a really cool deal at the Whiskey Cake, and it was like an educational deal. And I'm telling you, and I'm not bashing anybody that came to this event, it was just a lot older folks. And I think a lot of older folks.
We're in Grapevine. I mean,
Right.
It was a lot of older folks, man.
We're in a town that's a lot of silver-headed people.
Yes.
My clients are 2 to 3 times my age. Yeah.
Yeah. And so, being in that room and, I think just you did an excellent job with the presentation because obviously, we jumped on a call, me and my wife. But seeing that whole presentation the way set up, at the end of the presentation, I think 99% of that group was running to the back to talk to you guys just right away. Is this a big thing with our older folks? They're just not planned correctly, and they're just not educated, or they just don't know where to go?
Yeah, that is a big thing. So in that presentation, there's a slide that I get to, and it's why people don't plan. And on this slide, and there's 4 or 5 reasons that I lay out that people just go through life and don't plan for one of these reasons. It's too complex and they get overwhelmed, right? And they suffer from what I call analysis paralysis. That's where you see all the options, hear all the information, and you're just like, I don't know, I can't choose, and you don't do anything.
Yeah.
Right. And so you end up not moving forward at all. Right. And so that's a big part. They take that one step forward, and then they get overwhelmed. And then, of course, they think it's too expensive, or they just don't want to think about their own death. And I have to talk with clients all the time who get overwhelmed thinking about, their own death. And I always have to tell them, look, I get, death is scary. It is when you really think about that sometimes. But estate planning is not about you. It involves your things. It involves you, of course, your assets, and you're doing the work. But it's really about the loved ones you leave behind. And you understand this if you've ever been the executor or involved with a probate of a family member who's passed away, and you've had to go to court, and you really understand that it's, again, not about you. And sometimes you got to overcome that fear and take that step to make sure you have a plan in place to make things as easy on your family as possible, so they don't have to deal with the headache and expense of court, and they can just have time to grieve after you're gone.
Wow. What documents should every adult have before it's too late?
I mean, every adult should have your basic powers of attorney, right?
Okay.
So your medical and financial, that's really baseline. And then depending on, again, your situation, you're going to need some type of estate plan, as I said. So it's a will or a trust, again, depending on just your life situation. And that really does take a time to sit down with an attorney to go over with you, what assets you have, what are your goals, right? And depending on what those are, you may need some more advanced documents, but at bare minimum, you need something like your regular powers of attorney, a basic will. Just those are some no-brainer things that everyone should have.
So the top 2 documents everyone should have is the power of attorney, be it medical or
financial,
or financial, and a basic will. So,
and a basic will. Like at a bare minimum, if you have those documents, you will avoid a lot of headache, expense, heartache for your family should something happen to you, whether it be incapacity or death. Now, again, you can make things easier by going above and beyond, but at bare minimum, that's what I recommend to pretty much everyone.
Got it. Let's dumbify things again. What is a power of attorney?
Yeah. So we keep talking about medical and financial powers of attorney. So a power of attorney is a term that basically means you are giving someone the power to make decisions for you. And that's what it is. And you have 2 broad types. You've got the medical, which no brainer. You're giving someone the ability to make medical decisions for you if you're unable to make them yourself. Financial, on the other hand, is a little bit more complex. These can be incredibly customized, but generally you're giving someone the ability to handle your assets, make financial decisions for you. Right? And you can limit them. You can make them really broad. You can make them limited. You can, in time, you can say, hey, this is only good for a month, a year, in perpetuity. So you can get really complex with those, but that's generally what they are. And so again, what you do with it exactly just depends on what you're comfortable with, what your situation is. But that's what a power of attorney is.
And when you're going beyond that to, let's just say before we get to trust or anything, like a basic will or something.
Right.
Let's say you have a few kids and you have a hunk of money, you're from an oil family money here, or you're a rancher and you got a bunch of money, but you never wanted to deal with any of this modern world. And you spoiled your kids a bit much, and you bite the bucket, or this is maybe hopefully before you bite it. There can be a massive amount of greed, and things can tear a family apart.
Mm-hmm.
Let's get into that a bit. So, how can we structure things in a way to keep it where it's? Because I've seen families get destroyed from greed. Yes. Everyone feels like they are entitled to everything, especially if they were spoiled.
Right.
How do you lay it out in a way if you didn't parent well, and then your kids are spoiled, you got a bunch of money? How do you structure things in a way to kind of keep it to where you can minimize this fighting and stuff?
And that kind of ties into my next question. That's actually going to my next question. Can a family avoid fighting over inheritance?
There are definitely ways to minimize it. Obviously, the fighting depends on the individuals in question, right? How much of a stink they're going to raise.
Yeah.
But we can certainly minimize things. And so one of the great ways to do it is by avoiding probate. Right, when you have a court filing a court proceeding already going, it's so much easier to cause problems because you just get an attorney, they file into it, and it's pretty straightforward. They don't need to start anything themselves. And so keeping it out of a court process is incredibly helpful. So with a revocable trust or sometimes irrevocable trust, depending on the amount of assets you have. So that's a great first step. And then, of course, two other things that I'll really mention that I'll do three that will really help with people minimizing these things. So one is a no contest clause. Essentially just says, if you contest this trust, this will, whatever it is, you get disinherited. And so contesting meaning fighting, arguing, saying you deserve more.
You're banned.
Right. You get zero.
Excommunicated.
Wow.
Exactly. So that's one thing I'll put in pretty
No
much
more
all my
family
documents.
Christmases.
Exactly. Yeah. You're gone.
You're gone. The family dog's getting more than you.
You're off the island. Yeah.
Oh no. But have you ran into continue? But before you
Yeah.
continue, you ran into cases like that?
Oh yeah.
Oh really?
People
Okay.
will fight over the stupidest things. Yeah. I remember. I got gonna be vague with attorney-client privilege, but there was a family who was fighting over a house that was worth like $150,000, $150,000 with a mortgage on it, and they were just going back and forth in court, and I was, you guys aren't getting anything.
You're wasting money.
Just
You're wasting
It's all
wasting
going to the
time, a lot
attorneys,
of stress, not needed.
I know.
Oh man.
So, but yes, do you see people fight over just the smallest and stupidest things? It's ridiculous.
Wow.
But one way to minimize things even more is the revocable trust, keeping things out of that court process, the no contest clause, and then the actually talking with your family before you do what you do and kind of tell them. And I know a lot of my clients don't like to do that. They don't like to tell their beneficiaries, what their plan is. I'd like to keep that private, close to the chest, especially my my male clients. But if you're concerned that your kids might fight, and that's something I always ask about when I meet with clients, like, hey, how is the relationship with each other? How is the relationship with you? Are you concerned about fighting? Does anyone want anything specific? So I ask these questions, and that's why I always tell them, please have this conversation. Tell them what you're doing. So if there are feelings hurt, you can get them out of the way now before it blows up when you pass away. And then lastly, irrevocable trust for your kids, keeping things locked up, whether before you die or after you die, can really help prevent fighting.
You can go ahead and assign these things ahead of time.
Yeah.
You're done.
Yeah.
Move on.
That's a
Here,
tool
let's
to
get into
use.
another thing here. So I got a buddy of mine right now. His dad's in his mid-70s, and he's dating a 30-year-old. And he's like calling me like, hey, do you know of a good research way to check on her background? All this and that. And I'm like, well, this is this morning. There are gold diggers and there's next level gold diggers. You know what I mean? And I've seen this actually a few times. And with family law and things, if you just live with them a couple years, now you can make it look like you're married on paper, or I don't know. There's all kind of crazy stuff that can happen. For someone, say in my buddy's situation, he's got his dad. He's concerned about this gold digger rolling in there in her 30s, and his dad's ecstatic. And there's nothing he could say to him to talk sense into him. He is,
Son, I love her.
His dad is on cloud nine. He is happier than he's been since he was a child. But he's trying to say, well, hey, let's still take a reasonable approach here, because he lives in Miami Beach. He knows what's going on down there. His dad's in Connecticut. Is there a way where you've got somebody in the family coming in, the Tindler swindler kind of situation?
Oh yeah.
What are options in that situation, or you can kind of talk to the,
Dad's on cloud nine. He needs a little help.
Yeah. So the hardest thing is you really need to get the person on cloud nine to get on board with the plan. There are some small things you can try and do after the fact. Say, oh, you fraudulently made this new will or this new trust that left everything to you, right? You coerced him in some way, right? You can try and do that after the fact, but that's a losing argument. A lot of the time, very hard to prove, and at least in Texas, not a Connecticut attorney or a Florida attorney, but you can try and do things after the fact. But getting something done beforehand while he's alive is the hardest thing, but the strongest thing, right? If he, signs that post-nup, if they get married, or a prenup, and saying, hey, you don't get any of this, or make sure his estate plan is rock solid in some other way with a trust, whatever it is, that is what you want to do. And again, it's unfortunate that in order to have the best protection against those gold diggers is, you got to get the guy who wants the girl around, or potentially, I guess, the guy around too, who wants that person around.
It swings both ways.
Yeah.
Do you guys produce prenuptial agreements as well?
Yes.
Really?
Yeah.
Have you ever gotten into some weird cases where like a couple show up and the wife's like, I'm not signing this?
We've had some contentious. That's.
I thought you really love me. You don't have to.
Does it get into a situation for like a prenup battle, like the law, like before you get divorced, you have their representation? Like, hold on, I don't want to sign these terms.
So anytime we do a prenup, we have the two parties represented by separate attorneys. So we'll represent one side, they have their own counsel. Because one of the easiest ways to get a prenup thrown out
is to say that you
that, oh, I didn't have adequate representation. I didn't know what I was signing. And often you see this oftentimes where there's a big financial disparity between the two parties. And again, that financial disparity is usually because one's a successful business owner and the other's not. And so you really want to make sure at least that one.
Make sure that, hey, honey, here I
have an attorney.
Here's some money discreetly. Go get your own attorney. This is the one I recommend.
I don't know about the recommended.
Go down by the bail bond and
yes.
Here, go get you one of these.
I spent all my money on Gucci. I got this other attorney instead.
That's her prerogative.
What's one estate planning mistake you see almost every week?
I think it's the one I see all the time is just that clients who already have trust. Like I said earlier, they come in, they have their trust, and nothing's in it.
They're not using it properly.
They're not using it properly. They don't, and the reason that happens is not their fault. It's because the attorneys that they met with before did not explain to them what the trust is and what the trust does. They tell them, hey, you need something. You need a plan for when you pass away. I recommend a trust. Okay. And they're like, okay, fine, whatever. Pay the money. They draft it. Here you go. See you later. And so that's why that, 5 years down the road, 10 years down the road, nothing has been moved into it because they were never really told, or if they were, it was in passing, right? They're never told that how that trust needs to be operated, how their life needs to change, which not significant. You just need to start moving assets over into the trust, operating out of the trust. And again, I see that all the time.
How often should someone update their will or trust?
Good question. So when we tell all our clients, at least once every 3 years.
Once every 3 years.
At least once every 3 years.
What if you have anything? What if you don't have anything to update on your trust? Everything's going fine for the last couple of years. What do you still make a phone call?
I still recommend, whether it's virtual meeting, in person, whatever it is, you come and just talk with us. Let us review your documents once, or some other estate planning attorney once every 3 years. And I say that because the law changes, both federal law and state law changes, and that could have implications on your estate plan. Your life changes. You're married, divorced, someone dies, you get, someone else gets married and you don't want them part of it, right? All these things are dynamic, and depending on what your trust says and what the law changes, you may need to update, even though you don't really think so or you're not aware of it. And so that's why I can recommend at least once every 3 years, optimally once every year.
Got it. I'm going to dumbify things again. Let's just say, for an example, what happens if your children are minors and something unexpected happens to both parents?
So if your kids are minors and both parents are incapacitated permanently or for an extended period, or they pass away or something like that happens, unfortunately, those kids are going to need what we call a guardian. Guardian is someone who's going to take over that parental role from them, and that is done through a court process. And really, there's no way to get around that, because someone needs to be able to, sign them up for school, pick them up from school, or take them to the doctor's office, all these things. And so we can make it easier in that circumstance. But unfortunately, that's what's going to happen.
It's going to go through. Is there sort of a pecking order of blood relation, or can you kind of assign your godmother or godfather? Like, how's the?
Yeah. So courts really prefer, when they're in that process, close family members. However, as the parent, you can tell the court, who you prefer. And that's one of the things to make it easier, as you sign what we call a declaration or an appointment of guardian for your kids. And you say, hey, court, I know what the law says who you are supposed to look at, but these are the people I want to be guardian to take care of my kid in case something happens to me.
And as long as they're willing and able,
as long as they're
judge, they can kind of look at the situation and go, okay, this seems reasonable.
Yeah, exactly. As long as it passes
the address doesn't say Epstein Island on there.
Exactly. Yeah, something like yeah, as long as they pass the sniff test.
I don't want to go to Uncle Jeff.
Uncle Jeff, not again. I hate visiting Uncle Jeff.
Don't send me there. But yeah,
Who invited Jeff for Christmas this year? Creepy Jeff.
Yeah, that's what you can do to make it easier. But yeah, don't invite Uncle Jeff.
Can estate planning actually save money and taxes and legal fees?
Yes. Yeah. So as I said, when you go to probate, it just opens the door up wide for people to fight, people to argue. And of course, that court process is incredibly drawn out anyway before that. So that, I think in DFW, the average starting fee for a probate is about $5,000. So you're paying that out the gate for almost every estate planning attorney. So by doing your planning in advance, you're of course avoiding that fee. And then the, again, hours and hours of headache and time and the months of everything being drawn out. So yes, this proper estate planning can and help avoid, the legal fees and of course all that time and headache, and taxes as well, right? Thankfully, not a lot of people have to worry about the death tax, estate taxes, because it only applies if you have more than $15 million in assets. But if you are in that category, or if that exemption goes down, because it does change at the whim of Congress, it was supposed to be cut in half to about $6.5 million, but that was increased by the Trump administration. It kept it going. So we're at the 15 right now. But if that does come down, and of course, Republicans want to keep it high, Democrats want to keep it low. Again, just depends on who's in office. So if it does come down, that can bring a lot more people into having to worry about paying estate taxes. And estate taxes are no joke, right? So right now that rate is 40% of your of the assets you own that are again over that exemption amount. So it can be really, really significant. And of course, that includes, the face value of your life insurance. So that's not cash you have, right? It's just an asset you own, but they use that asset to calculate, where you're at. So if you have, a couple $1 million life insurance policy, if that exemption comes down, and it's been as low as $330,000 before, that's adjusted for inflation.
They'll cut into your
They're gonna cut in
policy.
Exactly.
and then you got to toss some taxes into it. Oh my goodness.
Yeah. So it's
interesting.
So yes.
So like Bezos or Elon Musk, these guys that have all this stock options,
$1 trillion.
Well, it's not real cash, but it's all this net worth. Like what kind of you maybe don't know exactly, but like what kind of rough things? So if you're at that level, you got a team of attorneys and businesses but are they just using different structures of trusts? Are they just using things like they still use things in the Cayman Islands? I don't know, or Switzerland, like gold bars in a bank in Austria. Like
when you have something that level of wealth, you're going to pay estate taxes, or it's almost unavoidable. However, there are things you can do to try and reduce that to the greatest extent possible, and obviously they got their team of attorneys who are working with them to do that. But again, when you have $1 trillion in worth and the exemption is $15 million, you can save. You're saving really what feels like pennies, and so you're still going to pay a hefty bill. But yes, we're using things like irrevocable trusts, LLCs, and other types of business entities to try and reduce the value. Life insurance is another great tool. I hear clients talk about the Rockefellers and their trust and life insurance setups all the time.
They set up for each grandkid, great grandkid. They all have their own policies sort of structured in a way.
Yep. Yeah. So they're using all of the above when you have that level of wealth to try and save and reduce
And to conserve it through generations.
Yeah, exactly. So
Don't let them just squander it.
to create generational wealth. Exactly.
Don't be a trust fund baby and go party it away. And I used to run into those guys all the time down in Miami.
Yeah.
I once dated a girl in New York. She used to tell me, like, hey, you should just tell people that you're a trust fund baby, man. You know, I was like, well, I guess. I don't know. I guess I'll try that out. Why not?
Trust fund babies.
I guess it'd make you fun at parties.
I was pretty fun, but yeah, I don't know why she would always tell me that. I don't know.
If someone has a trust or will more than 15 to 20 years, is it still valid?
Yeah, it's for the most part. All right. Outside of some significant legal change, generally, yeah, your will or your trust is still valid.
There's no crazy statute limitations on this stuff.
No,
Okay.
no.
But like you said, you want to update it.
You want to update it, right?
'cause laws change on a county level, on a state level, on a city level, whatever.
Well, is
Yeah.
it something that you can file, like where it's documented somewhere? Or like a lot of times I've heard about stories where like, oh, there was a will somewhere, and then when they die, they're looking for the thing in the house. Or they're like, I know it's somewhere, it's in some can somewhere or some file in their house, and they're looking
It's in
for
the
this.
I
shoebox.
had that experience with my grandpa when he passed away. So he was actually an attorney, and of course he was one of the guys who would say, we'd ask him, "Hey, Grandpa, do you have your will and stuff done?" Yeah, of course. Don't worry about it. And of course he didn't have anything. He didn't have zero. But we thought he did, and so we spent months scouring his house
Looking for it.
after he passed away, looking for it. Right. So I know that exact situation, and so I always tell clients, you can record it if you want to. And people actually used to do that all the time. They'd record it in the county records for that documented proof. Like, hey, here's my will. Everyone can go see it. But also that's now why people have stopped.
Because you don't want to be able to see your assets. And
Because you've kind of, you're putting your business on the
now people are going to trip and fall in front of my
public
office.
record, right? And then if you update your will or your trust and you don't re-record it, there's a big conflict there, and that can create problems. And so what I tell clients is you don't need to record it. Don't worry about that. But what you can do, and what I do recommend, is put it in a place where everyone knows about it. Everyone can go get it if need be. And make sure it is water protected or resistant, and fire protected or resistant, whatever. In a safe is a.
You guys use like asbestos tablets? How do you guys with a car?
So don't put it in a shoebox. That's what you're trying
Yeah,
to
don't put it in a shoebox. Yeah, what I always tell clients, a lot of clients, put it in their gun safe or their valuable safe at home. I don't actually like safety deposit boxes at banks because
you can't get access.
you can't get access to it. Exactly.
Yeah, if that happens, now you got to go through probate, and it's going to be 3 years before you can get in there. And
Right.
and then if you didn't pay that bill, now they're going to just get rid
And
of
see,
it.
it's worse though if you put the will in the safety deposit box, because probate courts, they only care about the original. And if you don't have the original, you're SOL. And so when you go to the bank to say, hey, so and so passed away, I need the will. It's in the safety deposit box. They're going to lock that thing up and say, go get me the order from the judge, and the judge is going to say, go get me the will.
Yeah,
and you're in a catch-22.
They're just going to keep your stuff.
Yeah, and it really sucks.
Does it happen a lot? Like, does it?
I
Quite
do
a
see
bit?
it happen.
Really?
I do see it happen quite a bit. And so I
Wow.
tell, whenever clients tell me like, oh yeah, I have all my stuff in a safety deposit box, like, please don't.
Take it out.
Please don't.
Your chances are better put in a shoebox instead.
Yeah. So keep it in a safe place where everyone knows about it. Everyone can go get it in an emergency. And then also I tell them, just go ahead and give copies as well. Give copies of your powers of attorney or whatever to the people you've named, and also to your financial institutions. Because one thing a lot of people don't know is powers of attorney are what we call documents of convenience. And that means, the bank, the hospital, whatever it is, can rely on that power of attorney, can accept it, or they can reject it. And they can reject it for basically any reason they want. Now, they have to give you a reason, but they can still reject it for basically any number of reasons. And so if they do, and you're incapacitated at that point, you're going to need to go to court to get a guardianship. And so the way you can kind of cut that off is by, when you do still have capacity, you've signed it, it's new, you can go ahead and give it to the bank, and then the bank can accept it. Or if they do reject it, you can go make a change to it, and whatever they want, whatever that change is, and then they'll be accepted on record. And so when something does happen to you, there'll be no hiccups.
Wow. Okay.
I know that was a lot.
I didn't know that. I didn't know that. Hey, put it in a shoebox. No, I'm just kidding.
Yeah. If all you get out of today is don't put it in a safety deposit box, it's a win.
You get to a catch-22 where you thought you're keeping it safe, but now you can't access it. And
Exactly.
Can the government decide who gets your money?
Yes, the state actually does decide. If you don't have a will, you don't do your own estate plan. That's what I tell clients all the time. If you don't do your own estate planning, the state will for you, which means the state will determine who gets your stuff and how much of it.
Oh.
let's say somebody, they don't have that much net worth. Say it's like, I'm not throwing out just a round number. Say they have a house. Nowadays with inflation, it's kind of hard to tell, but say they have like an old house, $100,000, just give a round number, and most of their medical bills ate up all their cash. You know what I mean? All their medical debt was there. They're in a situation. So when they pass and probate, are they waiting for all the collectors to kind of come in because they'll rack up $250,000 in medical bills, to try to keep you alive long enough to milk every last cent out of you. How is that structured in a way for like an average person to kind of see the probate's there, say they didn't have the will? Are they waiting just to pay? Like if people come in as like they have to have like a lien on you as a human being, like your social security number, like, no, hold on that.
Yeah.
I know there's like, you have credit cards, you have your mortgage on your house maybe, and then you have medical debt. There's a pecking order in there. I don't know. So it's like,
yes.
And then if there's any scraps left over for the family, they're like, there you go. Well, we're going to take our fee out first because we dealt with your stuff. Here's your crumbs.
Yeah. The attorneys are most politicians, the people who write the laws. So yeah, attorneys' fees come out pretty close to the top.
So you guys get paid. Judges get paid,
the top, but we're
pretty
we're
high up there.
But yes, there is a pecking order to debts. So you get what you call your secured debts, and those are your mortgages, your car loans, the things that have
Student
collateral.
loans are up there.
Student loans
Those never go away, do they?
are unsecured, but yeah, you can't really get rid of them, and
you can't be bankrupt. You
nope, you keep them. Yeah,
you have until you die, I guess.
pretty much. But yeah, so when you pass away, right, you've got all these debts, right, and so what happens is there's a 4-month period of time. So you got to post a notice. You got to advertise to the world that, and you do this in a newspaper still, but you post it in the newspaper that say so-and-so passed away. If he owes you money, come take your pound of flesh. And then everyone's got 4 months to do that. And then if they don't do that within 4 months, their claim is waived. If they're unsecured, if they're secured, they'll,
it's already documented.
They've got their stuff. But if it's unsecured and they don't come get their money within that 4 months, then they're in trouble, right? And so that's the period you're looking at after you go.
So 4 months, but so it's going through and it's going through probate. Like someone doesn't go and pay the $5,000 fee for an estate planner or attorney once it's going through probate. How does that process kind of unfold for someone? It's like I'd say the average person probably doesn't have that. I mean, most people don't have a pot to piss in. So like, how does that roll down that hill? How's the process kind of happen?
Yeah. So you're saying, what's the probate process like for someone who?
Yeah. So someone's dad or someone's wife dies or husband. Well, sometimes you can I mean, I don't know. So, sometimes a house will stay in probate for years and they just pay, as long as they pay the property taxes and it doesn't get foreclosed on, it'll just keep kind of existing. I feel like there's probably like a lot of ghost assets out there that never process.
There are a lot.
Or I don't know, people claim their grandma's Social Security for paycheck for, dress up and go cash that thing. And
yep.
I mean, there's all kind of weird stories you see of that thing. There's like ghost people that are just existing.
Yeah. Oh yeah. And you see that all the time, especially in the real property records. When you've got, someone who's passed away and then he's got a bunch of kids and then kids start dying and they're leaving it to grandkids and there's no proper documentation of it done. And so
a deed being transferred.
Right. And so
there's just a deed floating around.
Yeah. Well, there's really no deed. And so,
because it's not,
no one did anything. No one probated.
They actually never filed anything at the courthouse. So it's,
yeah. And so that can create a lot of problems, especially, in real property, when the whole idea is you want chain of title, you want one documentation going from one person to the other person. That can create a real problem when you're trying to buy, sell, or whatever. Now, when it comes to other assets, assets that don't really have titles to them, like your furniture, things like that. Unfortunately, you're not supposed to do this, but a lot of people, don't even worry about going to court. They'll just take it and split it. They'll look at the will and say, "Oh, you're supposed to get this. You're supposed to get that." If they do have a will at all, and then just split it amongst themselves, and then and that's really it. They don't go to court. You're not supposed to do that, but that's how a lot of people do it. Now, one of the things I do like to tell clients, I like to educate them, is when we're looking at potentially avoiding probate, trying to get to that, whether you have $1 million or $1 in your bank account, there are generally 3 types of assets that asset type number 1, what I call bucket number 1, are like jointly titled accounts. So think joint brokerage accounts, joint bank accounts. In that situation, if one of the owners passes away, the vast majority of the time, the surviving owner inherits everything in that account, regardless of what the will says or what other state law may say. And in that case, you can avoid probate that way, and a lot of people do, because whoever's the surviving owner, and oftentimes I see it, father and son, brother and sister, whatever it is, and then they just take the money and they're good. They don't need to worry about probate. Asset type number 2, bucket number 2, are beneficiary designated accounts. So think, life insurance, retirement accounts. In that case, when the owner passes away, the named beneficiary gets the asset, again, regardless of what the will says and regardless of what other state law may say. So you're avoiding probate with those assets. And so between those 2 types of assets, beneficiary designated accounts and jointly owned accounts, a lot of times, that's mostly what a lot of people have. And so a lot of people don't need to go through probate because that's all I got. Bucket number 3 is everything else. That's your personal property, it's your real estate, your business interests. That's what we call your probate estate. That's what your will covers. That is what needs to go through probate. Now, again, as I said, if it's someone who doesn't have any business interests or real estate, they just got some personal property, clothes, jewelry, that kind of thing. I see a lot of people who don't go to court to do it the proper way. They'll look at the will and just, again, divide it amongst themselves. Not supposed to do it, but I do see that all the time.
But for that situation, there's no major repercussions or... there's ICE already out there chasing people down. They got other things to worry about.
Yeah, unfortunately, it's really hard. Your shirt doesn't have a title to it, so it's
hard to show even. It's hard to show chain of ownership or
exactly correct. Yeah,
if it's not something a high enough ticket item, car or house or
and as long as people aren't fighting about it and they have everyone all agrees, oftentimes that goes totally unnoticed. Again, as an attorney, I have to say I don't recommend it. You got to follow the law.
Yeah.
But I see people do it all the time.
Wow,
that's interesting.
Interesting, man.
So you want to be careful about who's on your bank account.
Mm-hmm. Yeah, and
even if you're in a business account with a joint person.
Correct. Yeah. So I see clients when I talk with them, and they'll say, "Oh yeah, I've got a joint. I've got an account, and my brother's on it." And I go, "Your brother's on it? What do you mean by on it?" Because there are 3 ways someone can be on a bank account, right? You've got your a co-owner, right? That's the big one. You've got your authority as a signer, basically saying you have authority to access the money, but you don't have any ownership rights in it. And then you've got your beneficiary, which says, after the owner passes away, then the money goes to whoever it is. And so I always try and clarify with the client, which one is it? Because
hold on.
Because depending on
and I bet you I'll call you back. Let me figure that out.
They do. Oftentimes they don't know. They don't know.
Hey, brother, I don't know. Your brother's trying to pull cash. But the credit card's not working.
We've all had situations in business where you cut your business partner off like, hey man, you can't be in Vegas just blowing money. Hold on. Cutting you off here, buddy.
Yeah.
Mm-hmm.
On some island somewhere.
Yeah, is that the Uncle Jeff Island again?
Uncle Jeff Island.
They don't really track transactions out there. That's only in crypto.
Without giving legal advice, what would you recommend business owners do or tell them to do first to protect their family and legacy?
Yeah. Again, when I talk with business owners, they've got a lot going on. They got a lot of priorities. They're here to make money. And so I just got to tell them, estate planning is not about you. It's about your family, right? And then the biggest thing, especially if they have business partners, is you need to determine who's getting this ownership interest after you're gone.
Yeah, that business partner has families too.
Exactly. Mm-hmm. Yeah, is it going to your business partner, or do you want it going to your spouse, kids, whoever it is? And so, when you're a business partner, when you're a business owner, rather, especially with business partners, that asset is incredibly important because it's it's their baby, right? They've spent years growing it, developing it, working on it. And so making sure it's taken care of right so that it can continue functioning after you're gone. And that also brings up, if something does happen to you, who's stepping into your shoes?
Mm-hmm.
Who's taking over that business? Are you going to sell it? Or are you going to have, or is it a family business?
What's something, like you said, you guys have transitioned, you are in family, but you also do business planning and so to an extent. So
Right.
Let's take it down 2 scenarios. One, it's like a family business and you've got your kids involved, that kind of a situation. And then let's also go down another scenario that that you're a diamond wholesaler and you have 2 partners that have been operating together. One passes away and you both had responsibilities in the business, but now all of a sudden those responsibilities are gone. Like, how do you structure your articles of your corporation saying, hey, look, if you're not working, you're not getting paid. You know what I mean? I mean, a lot of times businesses are made on, but you're making money. So it's not like you have 50% ownership in a business, but you're actually bringing money in.
You got to work it. Yep.
Yeah. So like, let's go for like a family business idea. And then let's also go down like another, like a limited partnership or something. And then
I want to add something to what you're saying, because sometimes business owners, they partner up for a business.
Mm-hmm.
And so sometimes they write an agreement.
Mm-hmm.
If something happens to me, this goes to this person. Is that held liable on a will or a trust, or that just has nothing to do, or is that even held liable?
Yeah. So what you're talking about is hopefully what is a buy-sell agreement. So a buy-sell agreement is that contract that says, if I die or if I'm permanently disabled or any other number of causes, then you have the right to buy my share, to buy my interest out. Or it could say, you just get a right of first refusal. If you don't,
kind of that makes sense to me.
Okay.
Yep. Or if you don't,
But
then
you got to have it. You have to have it still, but you also have to have it already written out, though.
Correct.
These are the different options. They could buy them out. You have the first right of refusal to buy out. If not, then now you're gonna deal with my wife, and that's the reason I'm dying early. Don't suggest you go down that route.
I'm gonna leave that one alone. I know my fiance is gonna be watching, so
Post it up.
Okay, so let's run down those couple scenarios. So you have more of like a limited, like you have a family business, kind of, you got the kids and cousins or who knows what, and then also like another one's like a limited partnership. So like, how would you go not beyond just planning for like the will, but setting up the business? Like, what are a couple steps there that we kind of run down?
Yeah. So the biggest thing in a family business is whether there's multiple people in the family working or it's just a couple at the top. We need to know, again, who's going to be the next owner, who's that ownership interest, stock shares, membership interest, whatever it is, who's that going to, right? Are they paying for it? Or is it a gift to them? Right? That's the top concern, right? When we're in that type of situation. But close number 2 is, again, who's stepping into the shoes of the CEO, right? Because there's always that, couple of people, 80% or 20% of the people do 80% of the work, right? And so you're going to have those couple of people who are doing the vast majority of the work. Usually, the CEO, one of the owners, the founder. Okay, if you become incapacitated or pass away, what happens? Who's stepping in? Are you training someone to be able to take over for you? And unfortunately, for a lot of my business clients, they don't do that. And they never think about that, right? Because you're just worried about making money. You're just worried about growing your business.
I mean, you could be a $50 million business and you still are the main guy. I mean,
Is this pretty common, especially with that kind of volume?
Oh, very, very common. Yeah.
Really?
Especially,
Okay.
I mean, even you're even when you're making a $50 million business or something.
Or it could
like
be something
that.
simple like you're a dentist office, but you're the main dentist.
Right. Yeah. So
or you're a law firm and you're the main lawyer, or there's a lot of things where you're still kind of the main producer.
Guy. Right.
You're the dude.
And
you're the breadwinner.
and when that isn't the case, that has big ramifications for the value of your business, and a lot of people don't know that because some business owners will think, oh, I'm going to sell it, when I retire, and that'll be my retirement fund. And some think of it like that. However, if they're the guy who makes the money, no one's going to pay them anything for their business because you're going to step away. There's nothing there.
They'll pick up your book of business, but
right,
not exactly when you do the work though.
Yeah, if you're the one. That's what if you're the guy, if you're the money guy and you're gone now, that's just a shell with a book of business and maybe some assets, but it's not worth nearly what you thought it would be. And so again, that's something a lot of business owners got to think about if they're going to use their business as their retirement plan. Can this business work without you? Can it do the same or close to the same level of business if you're not there? And that involves, training that replacement, making sure your staff can operate independently, right? Are you just micromanaging everyone, or are you giving them the ability and training and knowledge to be able to work without your direct micromanagement, supervision, whatever you want to say? Right? And that's something that, again, a lot of business owners don't think about.
Yeah, I mean, this is a absolute fruitful discussion because that's exactly what you said. Business owners don't talk about it. And so whenever two business owners walk in your office and are like, well, we want to do this, do you ever see true colors come out from other side? I'm like, whoa, wait a minute. I didn't talk about that. I don't know if I want to do that. You ever see any of that stuff?
Thankfully, not so much. Most of my business owner clients are generally on the same page about kind of that's the reason they got into business together. They're generally on the same page. Now you do see disagreements, and you've got to kind of negotiate, right? Depending on who my client is, and that am I representing the company, one business owner, both business owners, right? Depending on who it is, you kind of try and negotiate and find a middle ground, right? That's why we're called attorneys and counselors, right? Because we're designed to counsel as well to try and help our clients, find a mutually beneficial solution without blowing everything up. Because if you can't find a solution, they're going to part, and then whatever this new enterprise is, it's going to fall apart. That's what this deal is going to fall apart, and that's not what I want. And unfortunately, I know a lot of attorneys get a bad rap for being deal killers, especially in a lot of real estate transactions, mergers and acquisitions. And I try not to do that. I try to help just grease the wheels as much as I possibly can.
Yeah.
To try and help clients get to where they want to go, while still saying, hey, these are issues, we need to work through them. Or getting to your point, if there are disagreements, significant disagreements, advising them, hey, here's something we could do that accomplishes close to the same thing, that's not so detrimental to the other person, and just providing different options like that. Because that's what, again, my job is. I have that legal knowledge to see all these tools available, again, where the client is, where they want to go. And then I have that middle part. I know the tools that we can use to get from one part to the other.
Wow. We're going to wrap it up here with the last ultimate question. What's the one thing you wish every family knew before it's too late?
I've said this a couple times already, but I've got another one though.
Okay.
Estate planning is not about you. It's about the loved ones you leave behind. Okay. I wish everyone knew that.
It's not about you.
Because it involves your things. It involves your assets, but it's really not about you. It's about your loved ones, making sure what you've left them when you're gone is not a complete mess. That's the big thing. The second thing I always like to tell clients is leave more than just your things, leave your legacy. What do I mean by that? Okay, everyone knows about, the father who just worked all the time, and now he's dead, and now I got $1 million or whatever it is, and that's all you have to remember him by. Okay, don't do that. You don't want your kids to remember more than just, oh, he left me a fat check when he died, right? That sucks, honestly, as a legacy. You want your legacy to be, oh, he left me this money, but also he taught me how to do this. We went fishing together. I have all these great memories with him. Right? We did all these things, give me all these life experience, this wisdom. Because you can teach wisdom, contrary to popular belief, you can teach it. And so you've built that through your career, throughout your life. Teach that to your kids, right? Or your beneficiaries, whoever those are. Right? Leave them with something more than just your stuff. Right? Impart knowledge, those good times that you could have had or should have had with them.
What's something that your grandpa left you? Other than looking for a wild goose chase for the wheel.
Other than looking for the
wild goose chase for the wheel. No.
A lot of discipline and respect, and just the appreciation for hard work. So he's German and Mexican, but he was raised in South Texas, right in the 1940s. course, incredibly discriminatory at the time. So he pulled himself up by his bootstraps, worked a full-time job, went to college, became a chemist, and then went to law school while raising, my dad and my uncles, driving. He got off of work at like 4 or 5 o'clock, and then would drive to Houston, an hour to Houston, to go to UTA, and then took night classes at the law school there for 7 years. He did that.
Wow.
To become an attorney. And then after he became an attorney, he served that community. I mean, you could look him up, Joe Silvas, in Gonzales, Texas, Calute, Texas. Anywhere around there, people know his name. He's passed away a few years ago, but a lot of people, all the judges know him. He left a lasting impact there with a service to his community. That's something I'm incredibly, incredibly proud of, and something we're trying to replicate here at our firm.
Wow, what a deep history with your grandfather and the roots. They go so deep.
Mm-hmm.
And what an impressive story, man. When I first met you at the event, I was something very special about you and the family and the way you guys operate. Everybody was great. I felt like when I met you and the team was super family friendly. You just want what's best for everybody.
Mm-hmm.
That's the kind of vibe I got in that energy. So, Mr. Nick or Nicholas?
Nick.
Counselor Nick?
Counselor, let's give it a wrap, man. We're gonna do a little
we're gonna do
clap
one of
like
these.
this.
On 3, 2, 1, boom!
Yeah. Thanks again for coming out to Founders Lounge.
Absolutely. It was my pleasure, guys.